Hi everybody, welcome to a Legal Buddy. So these are very brief lectures on various Indian statutes that are relevant. So today we are going to continue from where we left last evening. That was we were studying what is judicial separation in Hindu Marriage Act. So this would be an overview. I'll try to cover each and everything that comes under in judiciary exams. But if you want in detail lectures, you can mail me your queries at yourlegalbuddy09@gmail.com. I will write the email address in the description box. You can take it from there and we can have in-depth online and offline classes on it. ठीक है ना? Similarity between judicial separation and divorce क्या है? First of all, grounds are same. Grounds on which divorce can be claimed and grounds on which judicial separation can be claimed, they both are almost same. Almost, I mean not almost, but they are same exactly. ठीक? Judicial separation and divorce are upon same grounds as mentioned in section 13, and mandate of section 13 is also applicable on judicial separation. That is a fault based theory of judicial divorce is applicable on judicial separation also. Okay? Another same ground, another similarity is, as matter of practice, decree for judicial separation or divorce is not passed ex parte without hearing both the sides. Ex parte डिग्री नहीं पास करी जाएगी, ठीक है ना? Third, neither decree for judicial separation nor for divorce can be passed without an attempt made at conciliation between parties. ठीक है, अगर देखिए भाई without making an attempt for conciliation you cannot pass a decree for judicial separation or divorce. Very important point. ठीक. Last point or some other points are if decree for judicial separation has been passed for more than 1 year and there has been no presumption of cohabitation, the decree of divorce may be passed. ठीक है. जुडिशियल सेपरेशन का ग्राउंड जुडिशियल सेपरेशन का डिग्री पास कर दिया गया है एंड इट स्टिल कोहैबिटेशन hasn't been started, then this is a ground for divorce itself. ठीक है ना? अब 13A क्या कहता है? Let us study 13A from here. ठीक है, from Bare Act itself. 13A क्या कहता है? Divorce in Hindu Marriage Act. A very important, a very big and a very relevant topic for those who are practicing law. 13 of Hindu Marriage Act talks about divorce. ठीक है ना? Now 13.1 says any marriage solemnized whether before or after the commencement of this act may on petition presented by either husband or wife, the power to take divorce is both on husband and wife both. ठीक है, be dissolved by decree of divorce on a ground that the other party. ठीक है, अब इसके बाद इसने कई ग्राउंड दिए हैं जिस ग्राउंड पे डिवोर्स टेका जा यू कैन टेक द डिवोर्स फ्रॉम सम ऑफ द ग्राउंड्स दैट आई मेंशन बिटवीन. ये देखिए, ये है, दीज आर ऑल द ग्राउंड्स. इसको पहले हल्की भाषा में समझते हैं. लेट अस स्टडी फ्रॉम अ वेरी सिंपल लैंग्वेज, देन वी विल स्टडी फ्रॉम बेयर एक्ट. इफ petition has been passed for dissolution of marriage, then court as a matter of law and practice is not obliged to pass the decree of divorce if grounds have been fulfilled. ठीक. Instead, as an alternative, the court must initially pass decree of judicial separation in its own wisdom. अब वो कह रहा है कि अगर डिग्री ऑफ डिवोर्स के लिए मैंने कोर्ट से एक आग्रह करा है, if I have requested court to grant me a divorce, then the what court will say is, court will say first I will grant you a degree of judicial separation. वो फेल हो जाता है, then you can take divorce. ठीक है. After the passing of degree of judicial separation, the court must attempt for conciliation between the party. Judicial separation के बाद भी बात नहीं बनी तो conciliation के लिए भेजा जाएगा. ठीक. But if 1 year have passed since the passing of decree of judicial separation and parties have not resumed cohabitation, then court may pass the decree of divorce. ठीक है, वो कह रहा है कि judicial separation के बाद भी नहीं रह रहे हैं और conciliation भी नहीं हो रहा है, then the court says कि अब the marriage has gone beyond repair, then there is no point of living together, then it is better that you both go and take divorce. As a matter of fact, degree of judicial separation और divorce is not passed ex parte. ये हम लोग ने पढ़ लिया है. ठीक, ये हम लोग ने पढ़ लिया है, ये तो पढ़ चुके थे. सॉरी, आई हैव रिपीटेड दैट थिंग. ठीक है. What does 10.2 says? 10.2 कहता है degree for judicial separation doesn't need to end in decree of divorce. This is very important. Decree of judicial separation doesn't need to end in decree of divorce. ठीक है. ऊपर चीज जो हम लोग पढ़ रहे थे 10 जुडिशियल सेपरेशन का थोड़ा पार्ट छूट गया था, दैट वी आर स्टडीइंग. ठीक. The other possibility is that parties may reconcile their differences and either party may file an application to rescind the decree of judicial separation. अगर आप दोनों लोग साथ में रहने लगे हो, then what you can do is you can go file a application in the district court and say, मतलब जिस कोर्ट में भी आपका केस चल रहा है, and say कि now we are ready to live together and we want this judicial separation order to be set aside. वो set aside बहुत easily कर देगा. Mere commitment is not enough to rescind a decree of judicial separation. ठीक? The courts have to look into the facts and circumstances of each case, the satisfaction of other party and the strict proof of such commitment for decree of judicial separation to be rescinded. ठीक है? तो ये एक कॉन्सेप्ट था जो हम लोग ने थोड़ा सा डिवोर्स से जोड़ते हुए जुडिशियल सेपरेशन को पढ़ा. ठीक है? नाउ फ्रॉम नाउ ऑनवर्ड्स वी वुड बी प्रोग्रेसिंग टुवर्ड्स डिवोर्स. That is also very important. A lot of questions are asked based on that. If you want to go into extreme details with case laws, you can contact me. I provide online and offline lectures both. ठीक है? My email ID is yourlegalbuddy09@gmail.com. ठीक है? Thank you for watching.